Hey, Brian Parker here, doing another exciting video. I hope not to have any landscapers, air conditioning repair guys, dogs and cats fighting around me. I think today we can do a clean video. Well, I just noticed there's a cat up there. Okay, so, but he'll stay asleep. Today is a member's comment said, hey, I heard you do a throwaway. What's that about? And the throwaway was, I mentioned what's called the Statute of Frauds. And I talked about, hey, the word frauds, that's interesting, that's in the statute. So I practiced law for 32, 33 years. It went by fast. And there's always these laws or statutes that are in the peripheral. They're there and you may mention them, but you never really ingest them and live with them and play with them, even though most of my cases have a statute of frauds context in them. So today we're going to talk about what is the statute of frauds and how can you use it in your defense of a debt collection lawsuit. So it has the underpinning of what's called Article 9. Article 9 essentially is a national rule book for everyday business deals. So I think in the last 5 or 6 videos, you've heard me talk about mirroring, the concept that all laws are basically the same in any state. They're all mirrored off the federal rule book, if you will, with their own little state flavors. One of the most extreme examples of the difference between federal law and even other states is Louisiana, which is all set of its own set of rules down there, be they written or not written as far as the UCC goes. But generally, all state rules mirror federal or other state rules. You just have a template, and then you add your stuff, and you've got, why do all the work? You got a template. It's kind of the AI of it all. So look for the UCC in all of these, and I'll show you how. Essentially, this is what the Statute of Frauds is. So again, Statute of Frauds isn't necessarily all about frauds. It's really the prevention of frauds, and that comes in many contexts. So let's edit a Statute of Frauds. So every state keeps the same idea. That's that mirroring again of the federal UCC. Usually in a section titled Statute of Frauds. It lists transactions that judges think are especially vulnerable to fabrication. A great example of that is you make a promise with your buddy, if I ever hit the lottery, I'm cutting you in for 50%. Well, can you uphold that? So you're gonna know the answer to that real soon. So someone's promised to pay someone else's debt. Hello. Land sales contracts, that's the same as debts, that can't finish within a year. Remember that. Assignments or accounts. If the deal isn't in a signed writing that clearly describes what's being transferred, makes sense in a debt collection context. You've heard me say it all the time. Use their documents against it. Use the absence of your debt or following the law in the documents against them. The court treats it as never being existed. So it's not in writing, not signed, and doesn't fit your state's requirements. Is it a year? Is it under $600? Et cetera, depending on what the state is. It can't be enforced. So your application today is looking at the black letter rule of it all. So there's case law, there's legislators coming up with their own statutes. There's even some courts, like in Michigan, the Supreme Court promulgates rules for attorneys and how things are served. A lot of rules are promulgated with a lot of parts of the government. But black letter law can only be interpreted. It can't be changed unless it's by the legislature. So we apply the statute of frauds in the chain of title context. And there are certain cases in certain states, especially Michigan. We're going to go to Michigan-centric stuff today just to explain conceptually the concept of the statute of frauds. So attached to this video at killdebt.com will be, let me put it up there for you, Shazam, before we get going, an assignment letter. I'm going to create it. I love to create my letters. An assignment letter that you're going to send to a specific assignee that's suing you, or an assignor that an assignee is claiming, yep, that assignor gave us this stuff. I'll have a letter for you that you send. Again, some people go, well, what if they don't respond? Even better. What? Because here, Your Honor, I even asked them without having to do a lawsuit. I said, hey, can you just prove to me the basic elements of why you're suing me? Because I've sent you a validation letter, which essentially that's what the assignment letter is going to be, but putting their legal feet to the fire as far as the statute of frauds is concerned. And so if you can say, look, I sent them a letter saying, show me an assignment, show me it was in writing, and then you go, Judge, in, let's say, Montana, the statute in Montana, the statute of fraud, Your Honor, requires XYZ. I asked them to provide XYZ. To this day, you don't have anything. I've done that. Your Honor, if you have anything in front of you right now that shows an assignment from X to Y, I'll fall on my sword. And it's a great question because they don't have it. So that letter, you're asking them to produce it. You're doubling down on asking them to produce it. And if they don't, now it's even better for your statute of frauds defense. I'll attach my show notes. These ones were particularly hard today. I'm going to say to you, I put 3 hours into writing this dumb script today, okay? I say that because I probably won't use half of it, but I got into this thing today and I had so much more to do, but I just wanted to know myself what the hell I'm talking about so I can impart that to you. So the show notes will be good today. What's called a Weltman-Weinberg article will be attached to this. That's a very big collection law firm where one of their lawyers, I don't know why, wrote on their website and specifically looked at a Michigan Court of Appeals case that came down talking about this very subject and gave a favorable opinion that seems to go against everything that debt buyers and debt collectors go against. It essentially says, here's what the law is. You must do X, Y, Z if you're trying to assign a debt. And it goes against everything that a lot of debt buyers and debt collectors use. So I always, whenever I have a Weltman-Weinberg case, I attach that article to my answer or any motions. So you'll see the article. Why do I include that? Because Weltman-Weinberg is in a lot of states. I see him at least 2 that I operate in. So that means something. If the court is familiar with Weltman-Weinberg and what they're saying, it will say this, especially with the statute of frauds, it'll be on your side, the debtor's side. It's a great thing to, hey, look, even the lawyer from the plaintiff, Your Honor, agrees with me on this one. That's funny. And now, I love my check boxes. I created a checkbox so that if one of the boxes aren't checked, you can say, they violated the statute of frauds. They don't have standing. It's that important. Standing is the #1 thing. If they don't have standing, they can't sue you. This checkbox statute of frauds analysis will be that good for you. I'll have a checkbox attached to killdebt.com for you, all right? I created it just for you along with that letter. So what is the Uniform Commercial Code? Before we get going, again, it's a national rule book for everyday business deals, and it's something that all 50 states, with Louisiana, not so much, applying to their state application. So they mirror each other generally. If the debt buyer can't show that a signed account level document is not part of the transaction, the UCC, the Uniform Commercial Code, says ownership never attached. Ownership never attached. Remember that. So this UCC, this federal concept, as I said, state laws mirror federal laws, and that statute of frauds of each state will bring in a UCC component into their essential belief that if you have no clear signed paper, you have no clear enforceable claim. Plaintiff. So just remember, a sale, especially of your specific debt, never attaches if there's no signed, authorized writing. So let's look at that in the concept of a couple of states. First, Michigan. Let me put up Michigan statute of frauds as far as collection cases go. So Michigan statute, it's a statute of fraud, but Michigan statute in this area, 566.132, agreements, contracts, it's up there, promises required to be in writing and signed, meaning it's not enforceable or what's called void if a certain subject is not in writing. So Michigan has a long list of things that must be in writing in a sense. And F, so they say, 1, in the following cases, an agreement, contract, or promise is void. So there's two concepts in law. There's void and there's voidable. If something is void, it's out. There's no wishy-washy, well, it's penumbra or Bob wasn't feeling good that day and all mitigation. Void means gone, out and see. Voidable means, let's take a look here. Maybe he wasn't feeling good that day. Well, it's voidable, but let's just keep going and see where this goes. So you want things to be void if they favor you. You want things to be voidable if you want to live in the gray area. So in the following cases, an agreement, contract, or promise is void unless that agreement, contract, or promise, or note or memorandum of agreement, contract, or promise is, and I emphasize this, in writing and signed with an authorized signature by the party to be charged with that agreement. Therein lies really good case law for assignment people like myself in the state of Michigan and in other states. That authorized signature part is the subject of a couple of appeals I've got going. And also F, an assignment of things in action, whether intended as a transfer for sale, for security, or otherwise. Those are things, things in action. Let me put it up what things in action is. Shazam. A thing in action is invisible. It's no title deed, no car to hand over. The legislature demands paper to prevent fraud. So, and that's what the statute of frauds means. We're having a statute that says things that can be fabricated, or potential to be lied about must be in writing for the protection of both parties. So we don't have to take evidence. Did you really say that? Did she really say that? I saw Bob say that. I didn't hear Bob say that. So we just say, just put it in writing, so I don't have to have that discussion. So an assigner must sign a document saying, I assign Bob's $5,000 Visa debt to XYZ funding. It sounds like you don't need a law for that, but you do. We promise people stuff all the time. And I'll get into a great case for you you're gonna like in just a couple of minutes. So things in action is a way of telling debt buyers, show the signed paperwork you can't collect. It turns intangible liabilities, which are otherwise hard to verify, into paper trail assets that courts can police. I hope that makes clear what I just said. I want to quickly tell you, I just did a deposition, and I hope to have it up for you to view soon, of an attorney for a big debt buyer. And I said, how do you know my client's debt was bought by you guys? Well, we have the paperwork. I have this. I go, but that's not a debt. That's a printed ink on a piece of paper. What is a debt? And it flabbergasted the person I was asking, and an attorney being an attorney was objection form or something like that. Because what is a debt? How is your debt? What does your debt look like? You sign Visa, blah, blah, blah. It's an obligation indeed, but by the time it gets to a debt buyer, it's all fractionalized and already securitized. So what are they buying? What is a debt buyer that's paying pennies on the dollar with a bill of sale that says without recourse, no merchantability of title? What is it that they can go, look, Judge, he owes us? And I would say to you, it's really hard to prove. So this is the legislature trying to put that invisible thing by the time it gets down here into writing. So they want to put what it is my guy is accused of owing to Square Deal Dan in writing. But even in writing, so what I came down to, I got the person in the deposition to agree that the thing that my client signed is the original contract. That, without a doubt, is an agreement between the two parties, the original creditor and my client. He's saying I'm obligated. But by the time he gets to square Dan or this debt buyer, that's long gone. And you'll even see it in your creditor cases. It'll be a copy of possibly the agreement the parties signed with no signature. But the actual signature rarely signed a credit agreement finds its way into the debt buyer. So I would argue to you, Your Honor, and to this person that I depose, that you don't have the debt without the contract. And they don't. And so that caused a lot of problems. But again, this is the legislature's way of saying we need something in writing to at least push back on Parker. So let's take a look at a cool case. Forgive me, it may be tiny bit boring, but then it'll be kind of cool for you because I'm going to bring in this other cool case. So Shazam. That's the most recent published case law in Michigan. Published meaning it's binding. People have to follow this, as opposed to unpublished, where I've got plenty of cases, even that I've won, but they're unpublished. So you have the other side going, well, Your Honor, it sounds like he's correct, but that's unpublished, Your Honor, so it's not as binding. So my argument then is, well, what have you got? Because there's no real binding or unbinding, if you will, or unpublished case law that goes against the unpublished law that I have. I hope that makes sense. But this is binding in that it's published. So an assignment is defined as a transfer or making over to another of the whole of any property, real or personal, in possession or in action. Remember we just talked about what is in action, or any estate or right therein. To constitute, this is what we care about. To constitute a valid assignment, there must be a perfected transaction between the parties, which is intended to vest in the assignee, that would be the debt buyer, a present right in the thing being assigned. So that's an important twist that case, and it's been adopted as published binding law, a present right of the thing to be assigned. What does that mean? Look at Exhibit K. That comes filed with thousands of lawsuits every day, usually only by Velocity in fintech debts. So they shore up their belief that Velocity owns something by saying the original creditor, which is usually Cross River Bank, has sold the debt to Upstart, and now somehow Upstart's giving it to some weird trust, and now my client owes Velocity. It's just a tangled web. But look at number 2. Each of the loans identified by loan number on the attached Exhibit A. Each A loan was originated by Cross River Bank on or about the respective closing date at number 3 set forth on Exhibit A. None of that exists, and they say on the respective closing date, meaning they don't know when it happened. I point that out. So this is used by Velocity a lot and fintech cases. They say, look, here's evidence that the thing was assigned. That's not an assignment, because it is not assigning a present right in the thing assigned. It's saying on or about no date, something was transferred in this list of things on Exhibit A, no, not attached. I've been in those cases, have yet to ever see anything that shows the closing date or the thing that was attached. So if it said Bob's debt is attached and it was closed and assigned on September 18th, now we have a date, and that actually happened. But this is saying this happened in the past, essentially. Each of these loans identified by loan number was originated on or about the respective date. Something was transferred from Cross River to Upstart. That may be true, but it didn't happen with this document. It's reporting on something that happened previously. So it's not a present right to give something to somebody else. It's just saying something happened in the past. It's that easy. So essentially, what present interest did Upstart receive on here, June 30th? They received nothing on June 30th. My point being is, this is offered as an assignment, but an assignment assigns a present right. This is titled Exhibit K, saying something happened previously. So nothing is being signed, so it's not an assignment. The chain of title fails. It hasn't met the statute of frauds, at least in Michigan and most states actually. If you looked at Florida, let's put up, this is going to look boring, but I'm going to give you a great funny case, okay? Shazam. So Florida statute of frauds is a promise to pay another's debt. No action will be brought whereby to charge an executive administrator upon any special promise to answer or pay any debt or damages out of her or his or own estate, whereby to charge the defendant upon a special promise to answer for the debt, default, or miscarriage of another person, or to charge any person upon any agreement. It's essentially saying what Michigan and most states say. They add for a period longer than 1 year or upon any agreement that is not to be performed within the space of 1 year. And at the end, it shall be in writing and signed by the party to be charged therewith or by some person authorized. So that's essentially the same thing. It's got to be in writing, got to be signed, authorized. So there's a case called Browning versus Poirier, Poirier, 165 South 3rd, 663, Florida, 2015. Howard Browning and Lynn Poirier had an oral agreement that if somebody wins the lottery, and this is in 1993, we agree to split it. It hit. And in 2007, one of them, Browning, says, hey, where's my cut? And Lynn Ann says to Howard, sorry, Charlie, I'm not giving you the deal. We didn't have it in writing. So that's what I was talking about, oral, some invisible things should be in writing. So you'd think that this should be in writing. So let's see how the court looked at this. So Browning wanted their cut. Lynn says, no way, Charlie. So Browning sued for their share, claiming an oral promise that did not have to be in writing. Statute of frauds is about stuff that should be in writing because it faces fabrication and fraud. So Browning argued that the agreement was not covered by the statute of frauds and shouldn't be in writing because it could be performed within 1 year under the Florida statute. Boring you real quickly. So it has to occur for a period longer than a year or upon any agreement that's not performed within the space of 1 year from making thereof, meaning we thought we could get it done this year, but it didn't happen. But if it's possible to be performed in a year, you don't know what tomorrow's going to bring, so it may happen tomorrow. Then the courts generally will uphold that if it's happening after the year, but it was something that could be performed in a year. Just hear me out and you'll see what I mean. The Supreme Court ruled we agree with Mr. Browning. Despite the long passage of time, so you remember the agreement was made in 1993, the partner hit the lottery in 2007, the contract did not come within the statute of frauds. So if something doesn't come within the statute of frauds, what does that mean? It doesn't have to be in writing to be enforced. And it's because the contract's full performance is possible within 1 year from the inception of the contract. It's possible that agreement in 1993 could have happened a month later. Browning or Poirier could have hit it. So if it was impossible to have occurred within 1 year, that must be in writing. So the 1 year rule as far as the statute of frauds in Florida typically applies to contracts that cannot be formed within 1 year. Okay, I wanted to give you that kind of fun case just to give you, and hopefully a greater grasp of what the statute of frauds and why something should be in writing versus something that shouldn't. So like Michigan, Florida adopts the Article 9 rule that a sale of accounts or payments, intangibles, again, statute of frauds is talking about invisible stuff that should be in writing because invisible stuff, gray areas, somebody's not telling the truth. So it must be, as far as the UCC is requiring, an authenticated security agreement behind anything you're selling. So no action lies on a special promise to answer for a debt of another person, a debt, unless that's in writing. Now I'm going to show you a couple of states. For example, very quickly, I'll just put this up there for you, starting with Utah. Shazam. In Utah, the credit agreement covers loans and things in action. Like Michigan, you have to have an authenticated security agreement. That's the UCC, but that means you got to be in writing and signed. A debt buyer's purchase is a credit agreement without a signed bill of sale and authenticated schedule describing the account cannot enforce the debt. I'm going to tell you something cool about that down the road. In Texas, promise to answer for another's debt. You must have a loan agreement in writing, plus it must be over $50K when signed. All right, so that eliminates all debts, right? No, because your average debt sale is millions. It's not your debt that must meet the 50K standard. It's the batch of debt. So the bill of sale say, we're selling all these receivables, all these things that we think we own, but we're selling without recourse, receivables, judgments, bills, and that stuff adds up to millions. So I don't know why they threw the 50K in there, but maybe they don't want to go after small square deal Dans. The no things in action clause doesn't exist in Texas, but any promise to collect another's debt on a loan agreement over 50K must be in writing. So remember, your batch sale puts it always over 50K. In Montana, a promise to answer for another's debt must be in writing. Texas requires, just like Montana, that any promise to answer for a debt be in writing and be authenticated. When I say authenticated, a lot of my cases are where, in fact, if you look at, let's put up that, I don't know if that's the case. Quickly. Come on, Parker. All right, so a lot of cases, especially if you look at Brandy Riordan. If you have a Citibank case, it'll say Brandy Riordan is signing this assignment, which is so vague. Authorized party. Who says that's authorized? Just because it says authorized? No. In Michigan, and that Weltman-Weinberg article I was telling you, there must be a piece of paper saying, I have the right to sign. Otherwise, anybody can sign that and say that they're also authorized party. So an authorized party is someone that is authorized, especially if it's somebody like a debt buyer down the road claiming, we got it from Citibank. Well, who authorized that? So there must be some proof of authorization as well as the signature. So I will now give you some takeaways. Let's put the takeaways, Shazam, so wrap this up. Standing lives or dies in paper. Signed, everything's got to be in writing. Without a signed account-specific assignment, meaning, where's my debt in this nonsense? So the statute of frauds not only applies to debts having to be in writing, and I know you know what I'm going to talk about right now. They will attach a piece of paper, an excerpt, a redacted piece of paper that just shows you and your debt and maybe some contact information, and everything else is blacked out. And they go, see, that debt is inside that bill of sale that does not reference that thing that we're saying is the debt that's inside that bill of sale. Well, the statute of frauds, let's apply a statute of frauds. Is it in writing? Yes. Is it signed? No. You will not see, if you find it, send it to me, a signed excerpt or just a piece of paper. They say, yeah, here's your debt attached. It's got to be signed under the statute of frauds. So that's a cool takeaway. Apply your statute of frauds to this excerpt. So the bill of sale or assignment usually fails all day long because they don't have, there's millions of debts in there. Your debt's not mentioned in the Brandy Riordan, Citibank, or anybody else's bill of sale. But so they attach that piece of paper showing this is what's in there. It's got to be signed. It's got to be authorized under the statute of frauds. I just worked out a case I'm working on right now, just doing this. So the statute of fraud stuff is good. So in your answer, raise the statute of frauds explicitly. Plead it as an affirmative defense to attack any summary judgment motions, which I know I'm facing on this one case I'm thinking of as we're talking, to show that a assignment or an excerpt, this phony attachment they always attach to say, yeah, it's not in the bill of sale that we're claiming it is, but here's what's in there. And I had that in that deposition I was talking about. So I just worked that out too in my head. This is great stuff. So in litigation, if you get into the weeds, Number 4, demand the documents early. Use that letter. I'm going to give you a letter attached to this video asking for that. You can do it before you're sued or even while you're sued. Just ask who's ever saying they're a sign or assignee to show you something in writing of what they claim is the truth. Shouldn't be hard to provide the truth, right? So, at the end of these things I put, let me make sure it's still up there for litigation. Ask for the signature. Say, who's authorized to sign this? I see Brandy reading it here. Can you show me something she says that's actually her signature and she's authorized to sign this? And here's my letter. In that letter, it says, I want to see all the assignment people that sign this, and I want to see all the assignees. You're just asking for what they say is the truth anyway, so it shouldn't be a problem. So strategically, you can really nail them early on in your discovery. So I want to just, this is kind of the same thing. Shazam, statute of frauds uses, an unsigned allonge. This is a case that I have right now on a zombie mortgage debt. So the Brown Bar case in Michigan tossed a suit with a buyer stapled on a half-page schedule that listed pools of numbers that wasn't signed by the originating bank. You can apply that not just in Michigan, you apply that and find case law in any state with the statute of frauds defense that says, I need writing and I need signatures. In that case, it was an allonge that didn't have a signature where the person was authorized to sign that. You got to be authorized. Remember the statute, you won't, says it's got to be an authorized signature in Michigan. Now, that is the case in most states. That's a statute of frauds violation, and that means no standing. No standing means no case. Again, Article 9 lets a security assignment agreement incorporate another document only if the signed writing refers to it with reasonable certainty. So they can attach that Schedule A or the excerpt or whatever it is they attach. That's not me. And quickly in a case, I tried to tell this court that that extra piece of paper was worthless. And then I somehow got the word Mickey Mouse. I made my own excerpt and got it into the paperwork. And to make my point that this was just phony and so hearsay, I go, look on it, the one you're holding says Mickey Mouse is the owner. Woof, did I get in trouble for that? But I was trying to make a point, and the truth should set you free and my client free from liability. We should never be afraid of the truth. So that worked out well. I was making a point. I didn't do anything wrong, but I wanted to make the point that these things, without signatures, without authorization, anybody can make them up. And they did. So if the account's not on the list that they attach, that happens. Sometimes because they're making 500,000 of these lawsuits, they'll go, here's the bill of sale, and your client's in this extra piece of paper that's unsigned. You go, where's my client? That says Mickey Mouse. And that happens because they're in such hurry and don't care. Remember the 9 out of 10 rule. So end of this statute of frauds. I hope some of this makes sense as a defense and attempt to win your case and to kill standing. It's pretty simple, really. It's got to be in writing. It's got to be signed to be holding you accountable when clearly they're missing stuff anyway. So use this. It's a fun thing. Attached to the video at killdebt.com will be the assignment letter I'm creating for you, the show notes. Spent a long time on these today. I like to create content rather than report content, meaning I like to sit down and write for you like you've asked me to prepare a memorandum, because who wants to listen to me? But if I have this thing, hopefully you do want to listen to me and some of it makes sense and helps you, but I think you should demand that I do the work, that I know what I'm talking about. And then the stuff that I give you will be so much more powerful for you. Yeah, I go long and I talk on and on, but I want to assure you that I put work into the content that I produce. It's important to me that you know that. So these show notes represent that. I'm going to add that Woltman-Weinberg article from their own website. You can see how a collection attorney looked at the statute of frauds and how he favored us guys, the debtors. And then I've got a, I hope I do, I've got a checkoff box that I created, yes, that I'll attach to killdebt.com, where if any of these boxes are not checked off, then you can say, Your Honor, no check off, no standing. You don't have to, would attach this right on the front page of my answer. That's what I would do. I think the court would appreciate that. There's no rule against it. You're really just answering the lawsuit. So I have my answer, my prelim. I go, look. And so the court's going to go, okay, let me take a look at this. It's so unique to have that checkbox and include it in your answer. The court gets bored. They're human beings with a lot of work to do. So you got to stick out. So that checkbox, you want to grab onto that, killdebt.com. Lastly, mid-June of 2025, fingers crossed, you'll have the AI answer. The AI, the answer information you've all been looking for. I'm going to put my brain, my documents, there's probably 1,200 documents now of one form or another, of answers, counterclaims, answers to counterclaims, motions, answers to motions, discovery. You just put in your information or request. Like I was on ChatGPT. So this is going to be called ParkerGPT. So let's have the little airplane, ParkerGPT. And like I was on ChatGPT today, I was looking at a case. I say, hey, that case, by the way, ChatGPT is the worst for case law. It's always wrong. You got to verify it. So I think this is going to make it better where you're just going to have Parker stuff verified, done the work. And I said, here's an assignment. And I PDF'd it into ChatGPT and it plonked out some stuff. And I looked at it, was pretty good. That's how ParkerGPT is going to work. You will put in your complaint against you, or somebody's filing discovery, or somebody's, you want to know how to answer a federal lawsuit, or you want to write a letter. You want to write an assignment letter. Put into the chat box, if you will. It's not a chat box, so we're not going that way. You just put into the application your information, and up pops a letter, up pops an answer, up pops a counterclaim, up pops the most important document you can write, your counter affidavit. And remember, when you're doing this with ParkerGPT, the more you put in, the better your result. I do not want to be a service that does not do the work. I do not want to be a service that hasn't got tons of information so that when your answer shows up, when your counterclaim, whatever it is you produce from ParkerGPT, people are taking notice. Why? It's all about leverage. If an attorney's going, uh-oh, this guy knows what they're doing, that means something. I have plenty of debt collector friends. I really do. I'm not the type that goes, they believe this and I believe this. You just find another ground and it benefits both your client and theirs, right? So you find something in common with everybody. So I know they do not like to lose to unrepresented individuals. And as this AI revolution goes along, I think eventually in a couple of years, I hate to say this, attorneys will be less relevant and useful. If you don't believe me, look at doctors. We used to go and get our medical treatment, even tests, and then wait a couple of days, and then we got to go back in there. Can you tell me what this all means? Now you just go to Walmart or some service, Quest. They take your blood, and online you can get your results. That's where the law is going, and that's why I started killdebt.com. And that's why I am creating killdebt.ai. All our members, we're looking for 50 members, current members of killdebt.com to be, not guinea pigs, but to have fun for free using the AI application. So if you're listening to this or viewing this, send me an email and I'll make you part of that test plan where you'll get free use as a member of killdebt.ai. I want you to find mistakes, so eventually I make great gains and corrections and improvements on the site so that site is even better for you. I've talked a lot. I hope you understand the statute of frauds and what it means and what the title means. It does cover fraudulent activity. It's really a nice proactive way to prevent fraudulent activity that you can use against debt buyers and debt collectors. Thank you very much. Bye-bye.